Hello everyone and welcome back to day 2 of the Polity Daily Drill. Let's begin. First question. Consider the following statements. The Electoral College for Rajya Sabha comprises of all elected MLAs. A candidate contesting an election to the Rajya Sabha from a particular state should be necessarily an elector in that state. And number 3, all states and UTs have representation in the Rajya Sabha. How many of the above statements is or are incorrect? Please pay attention. This is incorrect. First statement. The Electoral College for Rajya Sabha comprises of all elected MLAs. Absolutely correct. When it comes to the Electoral College, meaning the voter list. So, who is allowed to vote? All elected MLAs of the respective states are allowed to vote. Statement 1 is correct. A candidate contesting an election to the Rajya Sabha from a particular state should be necessarily an elector. Elector meaning a voter in that state. For example, look at Sonia Gandhi. Sonia Gandhi was recently elected unopposed to the Rajya Sabha from the state of Rajasthan, right? However, does she belong to Rajasthan or does she vote in Rajasthan? No, of course not. We have seen her voting in the Nirman Bhavan polling area, that is in New Delhi. So it means that she is a voter in New Delhi. This means her name is in the voter list of New Delhi. But still she was allowed to represent Rajya Sabha or represent Rajasthan in the Rajya Sabha. This means what? This statement is incorrect. You need not be a voter in that state to represent that state in the Rajya Sabha. Your name can be in the voter list of any parliamentary constituency. There are various such examples like Nirmala Sitaraman. She belongs to Tamil Nadu but represents Karnataka. Or Dr. Manmohan Singh. In fact, this was a correct statement or could have been a correct statement before the year 2003. So you'll be surprised to know that before 2003, your name should have been in the voter list of that state or in that state only. And only then would you be allowed to represent that state in the Rajya Sabha. But an amendment was made in section 3 of RPA 1951, which removed that particular criteria. Third statement. All states and UTs have representation in the Rajya Sabha. All states have representation in Rajya Sabha, absolutely correct. But do all UTs have representation in Rajya Sabha? Of course not. If you look at Rajya Sabha, there are 245 seats in the Rajya Sabha, 233 elected seats, and 12 we know are nominated. Out of these, 225 belong to states and 8 belong to the union territories of Delhi, Pondicherry, and Jammu and Kashmir. So there are 3 seats for Delhi, 1 for Puducherry, and 4 for Jammu and Kashmir, making it 8. So only those states have representation in Rajya Sabha, or those UTs have representation in Rajya Sabha which have a legislative assembly, right? So 3 is also incorrect. Hence, how many statements are correct? 1 statement is correct. The question says incorrect. How many statements are incorrect? 2 statements are incorrect. Moving on to the second question. Consider the following statements. The Electoral College for electing the Vice President consists of all members of Parliament only. Now, this statement is absolutely correct. When it comes to the voting in the elections for the VP, MLAs are not included. MLAs are not a part of the Electoral College, are not a part of the voter list. And that's also a reason why there is no concept of vote value in the elections of the VP, because it's only MPs. Every MP has the same vote value. So 1 is correct. Coming to the second statement. A person is limited to a maximum of 2 terms as a vice president. Now there is no such limit. You can be a president of India or a vice president for any number of terms. And the third one, any elected MP or MLA can propose a candidate for the vice presidency. Now please understand, in case you want to contest elections for the post of president, for the post of vice president, for an MP, MLA, etc., somebody has to become a proposer. In certain cases, you also need seconders. Somebody has to propose your name. These proposers must be electors. It is mandatory that the proposer has to be an elector in that election. So in case of the vice president's election, if somebody has to propose the name or 20 people are required to say propose the name, then those 20 people must be electors. So MPs, yes, but since MLAs are not voters in the election to the vice president, they cannot act as a proposer. They cannot propose a name for the vice presidential candidate. So 3 is also wrong. Which of the statements is or are correct? A, 1 only is correct. Moving on to the third question. Consider the following statements regarding the collegium system for appointing judges in India. Number 1, the collegium to recommend names for Supreme Court judges comprises of the Chief Justice of India and 4 senior-most Supreme Court judges. Absolutely correct. This concept of collegium coming for the first time in 1993 and fully finalized in 1998, which is also called the third judge's case or the presidential reference under Article 143. So yes, if you want to become a Supreme Court judge, the recommendation is sent by a 5-judge group comprising of CJI and the next 4 senior-most Supreme Court judges. Mind you, seniority is not based on age, it's based on experience in the Supreme Court. For how long have you served in the Supreme Court? Number 2, the CJI has a veto power in the collegium. Absolutely correct. If the CJI does not like your name, he can negate it, he can nullify it, and if the CJI says no to a name, that name will not be sent forward for the president to approve or appoint as a judge. Even if other 4 judges agree, it does not really matter. The CJI must like you, right? So if CJI says, no, don't recommend this name, this fellow did not give me a pencil in class 4th examinations, your name will not be forwarded, you will not become the Supreme Court judge. CJI has a veto power to negate, to nullify. But if CJI loves you, you are his best friend, that is not a sufficient condition. Out of these 4 people, at least 3 people must support you along with CJI. So you have to have either 4:1 or 5:0 support. Otherwise, your name will not be forwarded. The third statement, the recommendations of the collegium are binding on the president. This is wrong. It is not binding. There is no fixed time frame, number 1, within which the president must appoint. And number 2, if the collegium sends a recommendation by 4:1, then the government can also send back the recommendation that Supreme Court, please check, why is one judge not happy with this appointment? So the name can also be sent back in that case. So of course this is incorrect. How many statements are correct? So 2 statements are correct. B is the right answer. Question number 4. Consider the following statements regarding the reorganization of states and UTs in India. Reorganization of states and UTs. This is reference to which article? Article 3 of the Indian Constitution. Bills seeking to amend the names of states or UTs can only be introduced in the Rajya Sabha. Nonsense. They can be introduced in either house of the parliament. Why only Rajya Sabha? So 1 is wrong. Such bills require the prior recommendation of the president before introduction. Yes, that's one condition, that in case you want to introduce a bill to reorganize the states, you need the prior recommendation of the president before introducing such bills. Third one, the bills must also be sent to the concerned UT for its opinion in case it involves modifying its name. Now, if a bill is brought to modify the name of any state or to alter its area, etc., you must also send the bill to that particular state legislature for its opinion. For its opinion. Now, this opinion is not binding at all, but the state has to be consulted. However, this condition is not needed for a union territory because a UT, as the name suggests, is a territory controlled by the union. There is no need to get the approval of the center because the bill is being brought in the parliament. Makes no sense. So third one is wrong. This would be correct if it was a state and not the UT. And the fourth statement, such bills require a special majority in the parliament for passage. There is no such need of any special majority. We know very well such bills under Article 3 are passed by law. By law means what? By law means a simple majority. There is absolutely no need to have a special majority. Simple majority meaning more than 50% of all the members who are present and voting on that day. So how many statements are correct? Only one statement is correct. That's A being the right answer. And the final question for today. Consider the following statements about Article 14 of the Indian Constitution, which embodies the right to equality before law and equal protection of the laws. First one, Article 14 applies equally to citizens and foreigners residing within the territory of India. Yes, this is correct. Please remember, there are only a few articles which are applicable only for citizens. Which are those? 15, 16, 19, 29 and 30. These are the 5 fundamental rights available only to citizens. Second statement, it guarantees absolute equality and prohibits any discrimination by the state against any individual. Now, there is nothing called absolute equality. The fundamental rights in our country are not absolute. We know that they are limited in their application. We can impose restrictions on them, right? In fact, if you look at this equality aspect also, all people are equal in the eyes of law, but don't we have exceptions in the form of Article 361 where there is special immunity given to the presidents and the governors? Apart from this, don't we have the parliamentary privileges for our MPs as well as the legislative privilege for our MLAs, MLCs? We have concepts like diplomatic immunity being given. So there is nothing called absolute equality. Third one, Article 14 permits the state to make special provisions for the advancement of any socially and educationally backward class of citizens. Yes, special provisions can be made for any class of citizens because Article 14 does talk about positive discrimination. So this is possible. There can be a positive discrimination which is allowed. And we do have positive discrimination in the form of reservations, in the form of differential tax rates, right? We have just seen the differential income tax rates, the new tax slabs being launched recently, that is from yesterday. So we know very well that such discriminations are possible and they are allowed and they exist. The fourth one, it ensures that laws are applied equally and uniformly to all individuals in similar circumstances without any favoritism or bias. Now, this is correct. The second part of Article 14, which refers to equal protection of laws, talks about this very concept of intelligible differentia, where we create groups of people placed under a similar circumstance and then treat them in a similar fashion. So 1, 3 and 4 are correct statements. Which of the above statements is or are correct? C being the right answer. This is Article 14, very important. This has been in discussion because of the CAA as well. So that's all for today, guys. We'll meet in the next video. Till then, that is all for me. Jai Hind.